In this episode of the BoormanLawyers Court Reports, we take a look at a middle-range drink driving offence that we appeared on at Brisbane Magistrates Court in the Brisbane CBD.
Yeah. Honestly, I think that 24/7 an understatement to my day-to-day. If ain't no way, then I'ma make a way. Niggas say it ain't no way. I ain't never listened, kept them at a distance. This is for the ones who ain't afraid. And this is more than a paper chase. I wonder who else can say the same.
G'day guys, it's Josh Boorman here from BoormanLawyers, and I'm pretty much just sitting outside of the Brisbane Magistrates Court here in the Brisbane CBD. I've just come out of court, the Magistrate Court on George Street, and I've appeared for a client on a middle range drink driving offence. His blood alcohol reading was 0.112, and it's an offence which dated back to the 1st of January this year on New Year's Eve. My client actually lives in Adelaide in South Australia. He had travelled up to Bribie Island to attend a party where he had pre-arranged to stay at the place, at this residence, with his sister. Now, just after midnight, they ended up getting into quite a large argument. A lot of nasty things were said. It got quite heated, and due to those unforeseen circumstances, my client was asked to leave the residence where he had planned to stay that night. So he was kind of left out in the lurch, in the dark, where he had no place to stay, and he had consumed alcohol. He did have his car there, and unfortunately he did make the poor decision to get into his car and drive from Bribie Island to Brisbane to look for some alternate accommodation for the night. But certainly he should have, on reflection, looked at alternative arrangements other than to get into his car to drive on that particular night. Now, we explained all of this to the court. We also brought to the court's attention that there were no serious aggravating features involved in my client's offence. He was pulled over for the purpose of a random breath test. There was no passengers in the car. He wasn't speeding. He wasn't driving erratically. There were no other charges that were laid. He was polite. He was cooperative with police, and he was open and honest about how much he'd had to drink. So we explained the circumstances of how the offence came about, the level of offending that it was at. It was in the the middle range at 0.112, so it was creeping up there, and he probably should have known better rather than to get into his vehicle and drive. Luckily for him, his Adelaide traffic record wasn't pulled up. He had a clear traffic record for the past 5 years, however had some previous DUIs about 7 years ago, which were not brought to the court's attention, and for the mere fact that they weren't in the last 5 years, it wasn't up to the prosecution to present that to the court. We presented some very strong character references in favour of our client. He does a lot of strong and good work for the community in his employment. He works in disability and respite care services. So this went to show that he is otherwise a person of very good character and gives a lot back to the community, and really not a blight on society whatsoever. It does show also that this particular incident was kind of out of character for our client, and due to the circumstances, it was unfortunate the way the circumstances came about, and not the way he would usually conduct himself. All in all, we received an outcome for our client. He was fined $900, received 6 months disqualification, and that was it really. He was happy with the outcome. It has taken almost 4 months to get here because we have had to adjourn it twice. It was initially in Caboolture Magistrates Court. It then got adjourned from there, moved down to Brisbane Magistrates Court. It got adjourned again, and finally we've been able to finalise the matter today. And predominantly these adjournments were due to the fact that our client does live in Adelaide and did find it quite difficult to get here to attend the court. But we handled all that for him, and he was happy with the outcome and very relieved that the matter is now put to bed and he can move forward. And take some significant lessons away from this entire ordeal. So guys, just shows you that drink driving offences can occur in the most unfortunate of circumstances, just like our client today. It is a message for everyone out there that regardless of the circumstances, you should always look for alternative arrangements rather than getting in your vehicle and driving after you know you've had alcohol or consumed drinks. So it is a big lesson for everyone, and certainly our client. But if you have found yourself in the unfortunate position where you've been caught drink driving or drug driving or any sort of significant traffic offences, rest assured that we specialise in traffic law in Queensland, and just like today, I attended Brisbane Magistrates Court. We attend all courts around Brisbane and Gold Coast and pretty much the southeast Queensland. So feel free to give me a call. My name's Josh on 1300 941 900, or alternatively you can go along to our website, which is BoormanLawyers.com.au. That's Boorman, BOORMAN, lawyers.com.au. There's a heap of information on our website. We've pretty much set it up to try and create a bit of an information hub to everyone out there on different aspects of traffic law, offences, penalties, recent case studies and results that we've obtained. There's a lot of videos, statistics and issues surrounding laws there. So it's worth going along to our website if you're in this position, making yourself familiar with the situation you may be currently in. And then if you want to clarify anything or talk to me about how we can best represent you when your matter goes to court, again, feel free to call me for a free initial first phone consult on 1300 941 900. Thanks for tuning in today, guys.